Good afternoon. My name is Adela Kowalski Garza. I'm a lawyer. I have been practicing criminal law for 30 plus years. And this afternoon I will be talking about the exclusionary rule and what it is and when it applies. In our criminal justice system, we have what are called constitutional rights. Everybody enjoys constitutional rights. Specifically, the United States Constitution provides some protections to all people regarding instances where there is police contact with the ordinary citizen. Those instances of police investigations that lead to contacts with people are in the area of criminal procedure. So the laws of criminal procedure encompass some of those constitutional rights. For you to understand what I'm talking about, police officers, when they investigate a case, they are limited in their conduct by the constitutional rights that we enjoy because they are mandated by the United States Constitution and also by constitutions of each state and also by federal and state laws. And so they must abide by those rules when they conduct an investigation. What happens when a police officer does not follow the rules to investigate a case? The rules are there, but they basically do not provide for any consequences or punishment to a police officer or to the authorities if those rules are violated. And these constitutional rights can be basically summarized in three basic amendments of the United States Constitution. The Fourth Amendment, which regulates searches and seizures by the police. The Fifth Amendment, which regulates and which has certain rules to follow regarding a person's rights as when he is interrogated by the police. And the Sixth Amendment, which gives all of us the right to have a lawyer in critical stages of a criminal trial or a criminal case. So the exclusionary rule is not found in the United States Constitution. If you read any of the Fourth Amendment, the Fifth Amendment, or the Sixth Amendment, you're not going to find anything written there stating what is the exclusionary rule. The exclusionary rule was invented by the courts, specifically by the United States Supreme Court, to give some teeth to those constitutional rights that I've mentioned, the ones in the Fourth Amendment, the Fifth Amendment, and the Sixth Amendment. Because without any kind of consequence or punishment, then it's really not of any use to have rights if nothing happens to those that violate those rights. The courts, when they invented the exclusionary rule, they took into account the challenge that the police officers have in investigating a case. When a police officer investigates a case and he's not only there to investigate cases so that justice can be served, but he's also there to protect and for ensure a society that has law and order. So they balanced the they balanced those challenges that police officers have with the importance that the lay person, the one that is not a police officer, with the importance of him having some protection against police abuse and police misconduct. So in balancing that, the courts decided that the police were not going to be exposed to either some kind of criminal liability, because that would make it very difficult for police officers to do their job, and therefore society would not, uh, it would not be in the best interest of society to have it like that. And they would, and the courts also said, well, we cannot also expose police officers to civil liability, meaning police officers being sued, because then again, that would have a chilling effect to police officers, and they would not be able to conduct their investigations without any fear of repercussions. So they came up with this middle ground consequence for police misconduct to deter police officers from not following the rules, to deter police officers from violating constitutional rights, and at the same time, not being so harsh on police officers where they would be basically afraid of conducting investigations for fear of civil or criminal liability. So that's where the exclusionary rule came about. It is a judicially created rule by the Supreme Court, by judges, that makes evidence obtained in violation of the United States Constitution, state or federal laws, or court rules inadmissible. And it means that if any evidence was obtained in violation of those constitutional rights, that evidence cannot be used in a criminal trial of the accused. One of the things that the exclusionary rule does is that it is considered a remedy, like I said, for evidence that was obtained illegally. And the way that that works is if a person believes that evidence was obtained illegally, that person is called an accused. And if the accused or his lawyer believe that the charges are based on illegally obtained evidence, evidence in violation of, meaning the police officers violated the person's constitutional rights when they did their investigation, and as a result of that, they obtained evidence, and they're now using that evidence against the accused. Then the lawyer files what is called a motion to suppress or a motion to exclude evidence. A motion to suppress is a petition to the court, to the court of original jurisdiction, the court that's hearing the trial. That motion is a request that evidence be excluded from the trial. It doesn't mean that the defendant is going to win the case. It doesn't mean that because that evidence has been excluded that the case terminates. What it means is that particular evidence cannot be used against the defendant, but if there's other evidence that was rightfully obtained, then that other evidence can be used, and that evidence may be sufficient to proceed with the case and maybe obtained a conviction by the prosecution. The type of evidence that can be suppressed can be divided into physical evidence, contraband, or instrumentalities. Let me just give you a short example. Let's say a police officer is on patrol and he sees a vehicle driving at the speed limit, and he decides to stop the vehicle for no reason, without probable cause, without reasonable suspicion, without exigent circumstances, without a valid reason to stop the vehicle. That would be in violation of the Fourth Amendment search and seizure, because the Fourth Amendment states that all people need to be secure in their persons and in the places and in their houses. So if you're and they all need to be secured of unreasonable searches and seizures. And when somebody is stopped by a police officer, that is considered a seizure because that person is not free to leave. So if a police officer stops a vehicle without any legal justification, that would be a violation of his Fourth Amendment right to be free from unreasonable searches and seizures. If during that stop, investigation reveals, or for whatever reason, there is a search, and the search concludes with the discovery of narcotics, and the suspect is later arrested for those narcotics, that suspect may file a motion to suppress because the narcotics were a direct result of the illegal stop. So he would file a motion to suppress the narcotics because they were a direct result of the illegal actions of the police. If he wins the case, if the judge agrees with the facts and so forth, then a motion to suppress those narcotics would, if it's successful, those narcotics would be excluded from the evidence. In that type of scenario, if there's no other evidence other than the narcotics, if that's the main essence of the case, then in that situation, it could lead to an acquittal or a dismissal of the case. But like I said, not in all cases, because if in other situations where there's other evidence than, other than the suppressed evidence, then it doesn't necessarily mean that the case gets dismissed. Let me talk a little bit about number 2, identification evidence. That is also, that could also be suppressed under the exclusionary rule. If the actions of the police violated a person's constitutional rights, and let's say while he's violating, he obtained fingerprints, or he got a handwriting sample illegally, or obtained blood illegally by violating this person's constitutional rights, then all of that evidence could be suppressed. However, when we are talking about identification of a suspect by a witness, by somebody that says, I saw him do this, I saw him, then that is a different scenario. And it is difficult to suppress an in-court identification from a witness of an accused. But I will explain that later, just so that you will know identifications of a suspect by a witness, and they are inside the courtroom, have different rules regarding that. Now, verbal evidence, confessions, and admissions are also subject to the exclusionary rule. So if a defendant is illegally detained in a police station and he is interrogated and he gives a confession, then it is possible that that confession by the accused could be suppressed if it was obtained in violation of either the Fourth, the Fifth, or the Sixth Amendments to the United States Constitution, or to whatever constitution in his state may have mandated, and so forth. There are some stages of the criminal case that do not, where the exclusionary rule is not applicable. For example, grand jury proceedings. When a grand jury is a group of people that get together in secret to decide if there's probable cause to believe that a particular person has committed a crime. And grand jury proceedings apply only in felony cases. And they are provided with a document called an indictment, which is a formal accusation prepared by the prosecutor. The prosecutor gives the indictment to the grand jury and presents the evidence to the grand jury. The defendant does not show up at the grand jury, and he's not entitled to defend himself or to even know that the grand jury is deliberating or considering filing formal charges against him in a felony case. Therefore, the exclusionary rule is not applicable in that situation. So somebody can get indicted with illegally obtained evidence because the exclusionary rule only applies in a criminal trial. And in this situation, it is before the trial. It is the situation to find out if there's probable cause to believe that the case should go to trial. In civil proceedings, it is still not conclusive to find out. It's not conclusive whether the exclusionary rule applies in civil proceedings or not. It depends. I'm not going to talk about that because I'm not a civil attorney, but at the same time, in some situations, the exclusionary rule is not applicable, but in other ones there is, and I'll leave it like that. Parole and probation revocation proceedings. Parole means that a person has been convicted of a crime and he was sentenced to prison. And he was released early without completing all of his sentence for good behavior while he was in prison. In that situation, if the parolee or the accused that violated his conditions of parole is in a parole hearing to see if his parole is going to be revoked and he's going to be sent back to prison so that he can complete the sentence, in that situation, the exclusionary rule does not apply. However, on probation revocation hearings, the exclusionary rule might be applicable. Probation means that a person who is not sent to prison, he is given a suspended sentence, meaning he's placed on probation for a period of time, and if he complies with all the conditions of probation, he can elude or he can not be sent to prison. And in that situation, there is some case law that states that the exclusionary rule is or may be applicable for probation revocation hearings. At sentencing, when we have in our criminal judicial system, we call it a bifurcated trial, meaning two trials in one. The first stage of that trial is called the guilt-innocence stage. The only issue in that stage is, did the person commit the offense, yes or no? It's very simple. Is he guilty or not guilty of the crime? The evidence that is relevant for the guilt-innocence stage of a trial is limited to that issue. Is he guilty or not guilty? Other evidence is not admissible because it's not relevant to the guilt-innocence stage, to the guilt-innocence issue in the trial. For example, if a defendant's criminal history is not relevant, and therefore it's not admissible in the guilt-innocence stage of the trial. Sympathy for the victim, that's not relevant in the guilt-innocence stage of the trial, so it is excluded because it's irrelevant. Also, sympathy for the accused, he may be very young, he was abused when he was a child. All of that evidence is also not relevant and not admissible in the guilt-innocence stage of the trial, because the only issue in that stage is, did he or she commit the crime for which he is being tried? Other stuff is irrelevant. Having said that, if the defendant is convicted by the trier of fact, either by a jury or by a judge, once he is convicted, then we move on to the second stage of the trial, called the sentencing stage. In federal court, there are sentencing guidelines, and one of those are called relevant conduct. That's a and in many states, what they do is they request an investigation as to the defendant's life. This is called a pre-sentencing report or a pre-sentence investigation report, a PSI. And if a PSI, pre-sentence investigation report, is ordered, the person that conducts that investigation is usually probation. They can use illegally obtained evidence to show to the court how should sentencing be. So for sentencing, the exclusionary rule is not applicable, but it is applicable at the guilt-innocence stage. Now, number 5, evidence obtained by non-law enforcement. Let me explain what that means. If you remember what the purpose of the exclusionary rule is, you will understand this particular limitation on the exclusionary rule. The purpose of the exclusionary rule is to deter police misconduct. The target is police. The target is law enforcement. So if somebody else obtains evidence illegally, the exclusionary rule is not applicable because it's not the police, the one that committed the illegality. It's somebody else. So that somebody else may be punished for whatever they did wrong, but it doesn't mean that the evidence that they obtained is going to be suppressed. It's going to be excluded. Let me give you an example. Let's say, and this is actually a true life example. In this situation, there was a murder, and the victim was shot. The police had a strong suspicion that her husband had shot the victim, but they did not have enough evidence to prove it, and they did not have enough probable cause to get a search warrant to search his house to look for the weapon that was used to kill the victim. And because they didn't have enough probable cause to get a search warrant, the case was pretty much going cold. The victim's or the deceased's son, who was a stepson of the accused, he decided to break into the defendant's home. And so basically he committed a burglary or a criminal trespass, however you want to call it. He committed an illegality. He did not do this at the request of the police. He did that because he wanted to do it. So, and nobody asked him to do it. The police were not the ones that told him, hey, go break into your stepfather's house and look for the weapon. He did that on his own. And when he did, he found the weapon and turned it over to the police. In that scenario that I'm giving you, the weapon that he found, that when he broke into his stepfather's house, the weapon that he found would not be suppressed, even though it was obtained in violation of a law. You know, you're not supposed to break into people's houses, because he's not a police officer. And the exclusionary rule does not apply to other people that are not police officers. Now, this is different in the state of Texas. In the state of Texas, it would apply because Texas has a different version of the exclusionary rule than the federal government. So if this case was a Texas case, that weapon would not be used in the criminal trial of the accused, because in Texas, under Article 38.22 of the Texas Code of Criminal Procedure, the exclusionary rule applies to all people, not just law enforcement. Therefore, if this is a Texas case, then that weapon would be suppressed.